Good afternoon, everyone, and welcome to our first webinar of 2022. Thank you for joining us today. We appreciate you taking time out of your busy day to join us for this topic, the focus of HIPAA investigations by the Office of Civil Rights. My name is Cassie Turner, and I'm the Manager of Risk Management here at TMLT. We also have Kathy Bryant joining us. Kathy, would you like to introduce yourself?
Good afternoon, and I am Kathy Bryant. I'm the Manager of Cyber Consulting Services at TMLT, and we're excited to bring you the first webinar of the year.
Great. Thank you, Kathy. So as I mentioned, the focus of HIPAA investigations by the Office for Civil Rights will be our topic today. Before we begin, just a few items that I would like to share with you. This presentation is available for download. If you look to the left pod that says Files, you can hover over the file and there will be an arrow that you can download the PDF of this presentation for today. Also, since this is the beginning of the year, we normally get a lot of questions about HIPAA checklist and getting everything in order for the new year. So in line with our topic, we'll be touching on some of the items on this list. So we included for you the New Year HIPAA review. It's a basic high-level compliance checklist that you can download and use at however you see fit for your group. Like I mentioned, we will cover a few of the things on that list, so we thought it might be a good resource for you. Also, at the end of the presentation, we will launch the CME evaluation. It will launch in your browser on a separate screen. So you'll see that pop up. If you would like to earn the CME, please just fill that form out and our CME team will process those certificates in the coming weeks and send them out to you. And finally, we will take questions at the end of the presentation. Feel free to go ahead and type those in that Q&A box that you see at the bottom of your screen. And again, we'll answer those as we get toward the end of the presentation. So there's Kathy and myself, Cassie, as we've already introduced ourselves. A brief disclosure here that we do not have any financial relationship or with any eligible companies, that this information that is presented to you today is as is, and it is not referred to as a primary legal resource. So our goals today are to identify the focus of OCR investigations, describe how we can prevent violations that were cited by the OCR in 2021, and discuss the importance of cooperating with the OCR and responding to their requests. So the OCR, Office for Civil Rights, enforces HIPAA and privacy security rules. And if you're interested, you can Google 45 CFR Parts 116. You will see all the rules come up if you've never seen them before. It's a good place to start familiarizing yourself with all of those rules. Their method of enforcement for these investigations are by investigating complaints that they receive, by conducting compliance reviews, and through education and outreach that they use to foster compliance. We won't spend any time talking about their work with the Department of Justice, but at times they do refer them to them for possible criminal violations of HIPAA. So how are complaints filed? It's quite easy to file a complaint with the Office of Civil Rights. It can be done through their portal. You can do a phone, fax, or email. They ask for the name of the covered entity or business associate that was involved, and they ask for a brief description of the violation. That must be submitted to them within 180 days, typically of the violation, although they will give a grace period if the complainant can show good cause as to why they were not able to submit their complaint within the 180 days. So as I mentioned, they have a portal. This is just a little snapshot of their portal. It's very easy to find on their website. And basically, who can file a complaint with them? Anybody can file a complaint with the OCR. I'm seeing that some folks are asking about sound. I'm hoping that that helps it a little bit. Anyone can file a complaint with the OCR, and Kathy's going to share a little bit more about some of the specific complaints that have been filed throughout 2021 and share a few more details on that toward the end of the program. But pretty much anyone, any person that is a covered entity could be the subject of a complaint filed with the Office for Civil Rights. So, do they investigate all of the complaints that are submitted to them? They do not investigate all of them. However, they will review all of the complaints and will take action on those that meet these conditions. So, if they review it and they feel that the complaint meets these criteria that are listed here, these 4 criteria, then they will take up an investigation and investigate further. So, the alleged action must have occurred within the past 6 years. The complainant must be filed against an entity that is required to comply with HIPAA rules. So what that means is a covered entity. Anybody that is a covered entity would be subject to the HIPAA rules. A complainant must also allege an activity that would violate the HIPAA rules. So if you're curious what those rules are, then you can take a look at those the rules that I mentioned earlier. And again, it must be filed within 180 days, and we do include a link for you here so that you can go and take a look at those if you would like. So if a complaint is accepted for investigation, they decide it meets that criteria, then they will notify the complainant, the OCR will, and they will also notify the covered entity that was named in that request for investigation. The complainant and the covered entity are both asked to present information about the incident, and the OCR may request specific information from each of you to get an understanding of the facts. So when they do come to you, and Kathy will elaborate on this, is working with them and coordinating and providing the information that they're looking for and cooperating. As this next point points out, it is required by covered entities to cooperate with any complaint investigation. Even if it's just an investigation, you're still required to cooperate with them.
So as you're going to see as we go through the next portion of the presentation, there are a lot of overlaps between a reported or a complaint investigation and a breach report investigation. First, I can't start 2022 without just a little reminder that if you are a covered entity, you are required to notify the Secretary of Health and Human Services of all breaches. On those small breaches, which is considered less than 500 individuals involved, you have until you have 60 days after the end of the calendar year in which the breach occurred to report it. So these are those what we call little breaches where you might email or mail someone with a similar name someone else's lab work. The person that receives it calls and says, why am I getting Mrs. So-and-so's lab work? That's not me. That's when you write a letter to the patient whose lab work was sent in error and notify them that it has been done. And there are many requirements of what that letter has to contain, but that's a very short type of breach. It doesn't involve hundreds and hundreds of letters going out. It doesn't require a call center, all the things that large breaches require. So you have two choices. You can either report those to HHS when they occur, or you can wait until after the close of the fiscal year, or the calendar year, I'm sorry, and report all of them at one time. So just a reminder, that's approximately the last day of February. Sometimes it's March 1st, sometimes it's the 29th. This year it's technically the March 1st, but I always just try to get people to think of it as I have to do this by the last day of February. Now, that's way different than if you have a breach that involves 500 or more individuals. Those must be reported without unreasonable delay and in no case later than 60 days from the discovery of the breach. So if you had a breach on January 1st, get a calendar out, count, find out what the 60th day is, and that's the date you have to report by. There have been cases where people have actually had notification or have had issues during investigations because there was a delay in reporting to the OCR. The OCR will investigate all breaches of 500 or more individuals. That's just their rule. They can investigate the smaller breaches, but in the last bit of time, we haven't seen any resolution agreements with smaller breaches. So just keep that in mind. If it's a breach of 500 or more, you can probably or you'll be guaranteed that the OCR is going to open an investigation. So when the OCR opens an investigation, the organization will receive a letter from the OCR. This can happen very quickly, sometimes in a matter of days, or it can take months before you get that letter. It will list all the possible HIPAA violations that they believe may have occurred, and they will start by asking you for a long list of documents that they want submitted. And that request of information is usually due in 20 days. It's important that you work with your attorney and get that filed in a timely manner. Each investigation is somewhat unique from the OCR. I've seen some investigations that are resolved within just a couple of months, while others will take years to resolve. And I have an example a little later in the program. Oh, sorry, it's on this slide. Sorry, I was going to go into a little more detail. So there are some that take years, and it is not uncommon for the Office for Civil Rights to issue multiple requests for information, and generally with subsequent requests that 20 days shrinks and continues to shrink because they're wanting you to respond quicker and quicker. So there was a case that was settled last year. It's the case of Dr. Robert Glasser. He is a solo practitioner in New York that basically did not cooperate with the OCR's investigation or respond to the OCR's data requests. So because he failed to provide a patient with a copy of their medical records. So here's kind of the scenario. If you want to read more in detail, there is a hyperlink about that. So way back in 2017, a patient complained that Dr. Glaser had failed to provide medical records, and the patient had asked several times. About a month later, the OCR closed the complaint and just sent some technical advice, as they call it, by a letter to the doctor explaining the allegations and that there may have been noncompliance, and basically check your processes and don't do this again kind of thing. About a year later, March of well, not quite a year later, about 3 months later, March of 2018, a second complaint about the doctor failing to provide copies of their medical records was received by the OCR. They sent they sent a letter in August notifying the doctor that they were initiating a complaint, because that first case that got resolved, those letters clearly state If we get another similar complaint, we will open an investigation. And that's exactly what they did. So they opened an investigation, and the doctor did not respond to the letter. After about 2 weeks, the OCR called the physician on the phone and spoke directly with the physician, who requested an extension and was actually granted a 2 week or a 10-day extension. However, the doctor did not provide the response within that 10 days. So now we're up to September of 2018, if you're keeping track. Between September of 2018 and September of 2019, there were 5 additional contact attempts that I could count in the record, none of which were responded to. In November of 2019, the OCR sent the doctor a letter of opportunity to settle the investigation and close the investigation, and the doctor chose not to respond to that. Finally, the OCR last year obtained the authorization from the Attorney General of the United States to issue a notice of proposed determination and impose a civil monetary penalty. So there are HIPAA violations that they can impose a penalty on. And then on top of that, there are civil monetary penalties, and these are not very often done, but when they are, there's usually some pretty egregious situation. I mean, if you think about it, this physician went for 2 to 3 years without responding to the OCR. So it's a really good example of how important it is to cooperate with the OCR investigators and not ignore letters and phone calls. If the evidence indicates that a covered entity was not in compliance, the OCR will attempt to resolve the case by obtaining voluntary compliance. And most often, in the cases that I've seen, they are actually able to get a resolution through voluntary compliance. That voluntary compliance is sometimes associated with corrective action, and that may or may not be with a financial penalty that is described in the resolution agreements. As I said, most of the investigations are resolved. Very few of all of the cases in the OCR branch or the OCR seem like they end up in resolution agreements, and we're going to look at all of the 2021s in just a moment. But the bottom line is compliance helps avoid violations. And the top things that we see as being issues with compliance are that you must do a HIPAA risk assessment. You must have written policies and procedures, and you have to educate your staff on those. You must have a policy in writing and follow it on how you're going to respond to an individual's request for copies of their medical records. Employees must be trained, and that must be documented. You need to have business associate agreements executed and in place. And more, we're seeing the OCR look at what your cybersecurity measures are. I apologize to those of you that are continuing to have issues with the audio. Uh, we cannot see anything on our end that we can correct. I will just remind everyone that there will be a recording that will be sent, a link will be sent to you of that tomorrow. And if that recording for some reason doesn't resolve, Cassie and I will re-record it and make sure there's a good quality recording before we send that out to you. So if we look at all the breach resolution agreements in 2021, then we can see that the OCR really didn't have a whole lot. The first one was one that dates way back to originating in 2015. This was a health plan that had a very large breach and was assessed a very large penalty. As you can see, almost every other one is about a right to access medical records. And we're going to look at those in just a moment, a couple of the examples. So the Denver Retina Center is a fairly small practice. The OCR's investigation showed that they failed to provide timely access to medical records, and there was obviously a complaint by the patient. The findings of the investigation was that the Denver Retina Center failed to have sufficient written policies and procedures related to providing timely access to protected health information about the individual. And this is probably, or this is the most frequent violation that we're seeing, that a practice does not have a policy and procedure in place about handling those requests, and then that the requests are not being actually responded to in a timely manner. The large breach that I mentioned just briefly was the Excelsius Health Plan. Like I said, this was back in 2015 when this breach actually occurred. And I think it's important to point out that number one, there were 9 million people involved, and that may be part of what drove the $5 million plus settlement agreement. But if you think about it, the OCR investigation found potential violations for failure to conduct an enterprise-wide risk analysis, failure to implement a risk management plan, failure to have information system activity review, and adequate access controls. In fact, if you kind of dig into this breach, the hackers were actually on this system for over a year before the health plan discovered that they had been hacked. So the hackers were in their system for a very long time. But I think even for smaller practices, you're required to monitor your information systems activity and maintain cybersecurity measures that would help to prevent and/or detect hackers from getting into your system. Aon Clinical Laboratories is another covered entity, and they had a breach. In the breach investigation, the OCR found that they had failed to meet the basic security rule requirements. The OCR believes that because healthcare as a whole has had some lacking cybersecurity, um, or has lacked in keeping up with cybersecurity, they feel like that makes healthcare kind of a target or low-hanging fruit in some cases. So our lesson learned is that you need to know the rules and have written policies and procedures, document your compliance, and focus on enforcing those policies and procedures that you have in place. If we look at large breaches reported to the OCR in 2021, it wasn't a very good year. There were 686 breaches of individuals, of more than 500 individuals reported last year. And this is potentially subject to going up because if there was a breach late in, even in November and any in December, they have 60 days to report those. So we anticipate that this number may actually increase. It is considered the worst year for healthcare breaches. In fact, 44.9 million healthcare records were stolen or exposed in 2021. 245 breaches had more than 10,000 records involved. 25 breaches had more than 500,000 records involved. And about 75% of all the breaches reported were tied to a hacking or IT incident. Unfortunately, like anything else with federal rules and state rules, and there are consequences for noncompliance. As you can imagine, simply navigating the maze of noncompliance and the investigation by the OCR is very time consuming. Imagine if a couple of the incidents that we looked at, those investigations went on for years, and that's going to take time away from your usual business. And in medical practice's case, that time away from your usual business is patient care. There can also be the financial impact, both of additional expenses related to a breach and loss of revenue. There can also be harm to your reputation, as well as fines and penalties. And I would just like to remind you that if you have cyber insurance, most of the cyber insurance policies have a reporting requirement that requires that you have a certain amount of days to report that. I always encourage you to make that initial response of a cyber incident sooner rather than later, because you're going to want the assistance of a cyber coach or a cyber attorney to help guide you through the process, whatever that needs to be, as well as you're going to want to have the the payment for all the things that might be involved. Especially something like forensics is very, very expensive, and you certainly want to have your cyber insurance approve that if possible. Again, I apologize for those of you that are having difficulties trying to get audio. I'm looking through the questions or comments that have been posted, and I believe almost all of them are related to audio. Um, Cassie, did you see any other questions that had come in from the audience? We'd certainly encourage you to continue submitting questions if you are able to hear the presentation.
No, Kathy, I didn't see any questions yet, and I know we're at that point toward the end here. So if you do have questions, please do feel free to type those in the Q&A box, and we'd be happy to help with those.
We also do take questions if you think of something tomorrow or somewhere down the road about something that was that was presented today. You can email us at consulting@tmlt.org, and we'll be happy to answer those questions as well.
So, Kathy, one question here. Does TMA give you access to check my practice for HIPAA risk?
Does TMA?
Yes.
I am trying to think of the TMA does have some HIPAA resources, I think including some of their practice management personnel coming out and doing consulting work with practices. But I think you would have to reach out to them to see if they have specifically what you're looking for.
Right. Another question in line with that, Kathy, is what is the best way to get a risk assessment of the practice for HIPAA compliance?
So there's really lots of ways to get a HIPAA practice or HIPAA risk assessment. There are self-assessments that you can do that are available through the Office of National Coordinator. There are also self-assessments that are done by a variety of companies. And like I said, I know TMA has done some risk assessments in the past, and you can always check with your medical practice or your cyber insurance carrier to see if they have resources or recommendations.
Perfect. A couple of questions related to access. One, the patient's request records via email. In this case, how do we respond?
So in 2013, and since 2013, the OCR has tried to clarify a couple of times about a patient getting records by email, even if you don't have a secure email process like encrypted email. Of course, from a cybersecurity standpoint, we would always encourage you to try to have a secure way to share records. But if the patient requests their records be emailed and they insist on them being emailed, even after you issue or remind them that sending them by regular email is not secure, if they are still insisting they want them by regular email, you need to document that you've warned them that they may not be secure, but then you can actually send them that way. But the patient has to, number one, the patient really should initiate that. It's not you calling up and saying, hey, do you want us to issue these by a regular email? And then secondly, there is we would encourage you to make sure that you have an option, whether that is through your portal, whether that's through secure email. But the answer is basically yes. You can submit or you can request that, you can honor a request for emailed records.
Perfect. Another question is related to fees, Kathy. If a patient is refusing to make that payment, can the practice withhold the records, or is that a violation not to release the records to the patient?
So is if the fee is related to they owe you money for having a balance on their bill, you cannot withhold records because they owe you money for services. If you do request a medical record, or if you're requesting payment, the OCR really feels strongly that if it is for the patient, you should try to actually make sure that that patient does not have does not get, or it's not an impediment to them getting the records by charging a fee. So if you can at all, try not to hold records for fee payment. And that is for the patient.
And then, Kathy, you already mentioned a little bit about patient portals. The question is, do patient portals increase the risk of a HIPAA breach?
Actually, most patient portals are very secure. And if you have any questions about that, you should actually be checking with the provider of your patient portal.
It looks like that might be the end of the questions. Again, if you have another question, please feel free to go ahead and add it, but it looks like that is the end of the questions. Again, we do realize that some of you have experienced some audio issues. We will go back and listen to the recording and make sure that it's a good quality. If the quality is not good for the link that we will send out, Kathy and I will re-record the information so that you can have access to it.
I'm going to go ahead and launch the CME evaluation. If it covers your screen, simply minimize that tab in your browser and you'll return to the presentation. And yes, please give us feedback. I know it's frustrating. Oftentimes the problems are outside of our control, but we'll certainly investigate those to see if we can't come up with a solution. If we do have to record the webinar or re-record the webinar, it may not be available tomorrow. We just have to get that on everyone's schedule to get that done. Remember that the slides are available for download, as well as the additional New Year HIPAA review checklist. I think we have another question that came in. If a patient is in the office and wants a copy of their lab work, do we ask them to sign a medical release form? You need to have a policy on that, but the reality is that if the patient is sitting right there, you know who the patient is, you know who the request is coming from, and you can certainly print out a copy of that and simply give it to them if that is within your organization's policy, and be sure and document that you gave them a copy, so if they ever file a complaint later saying they asked for a copy of the record and you didn't give it to them, you have documentation. Looking to see if any other questions are coming in. Again, we appreciate your attendance today. Next month, our topic is contingency planning, because unfortunately we're seeing more and more healthcare practices affected by ransom attacks and other kinds of cyber attacks. And being prepared with a contingency plan is very important. So we look forward to presenting that next month on February 22nd. And the registration information will go out about 2 weeks in advance. I see another question or two has popped up. Has there been any OCR reports by patients stating that records were not released on time by another physician who had requested for records? Um, that would actually fall into a different category. The OCR investigates the patient requesting records for their own use. And if the patient is going to take those records and give them to another physician, that is one scenario. However, if the patient is requesting you send records to another physician, I'm not aware of any of the settled cases that have been that the practice failed to get the records released on time. I am aware of Texas Medical Board complaints where records have been requested to go to another physician, and then the sending physician did not send them in a timely manner, and that there have been Texas Medical Board complaints opened or investigations opened. So it's best to know what that policy is and to make sure that you are following it. And just make sure that that's a high priority for your practice. What about if a patient refuses to sign a release? So I think that's a two-part question. Let's start with the first one. If a patient refuses to sign a release, and if this is not where you're going, doctor, please feel free to type some additional information. But if a patient is requesting records for their own use, you may have them sign a simplified release for medical records just for documentation for your practice. That is totally up to you because you do not have to get by federal law, you do not have to get a written request signed. I'm of the opinion that Texas law says you have to have a written request. But again, I wouldn't risk not giving the patient their records because they won't sign a piece of paper. We're seeing far too many actions against practices for doing that. In the general concept of not providing the records in a timely manner. If you are sure that the patient is who is requesting the records, then I'd be careful about that. There is another part of the HIPAA law that talks about that you shouldn't hold the patient not signing a medical records release, such as if you wanted to get records from another physician. You can't really not see the patient or penalize the patient for not signing that. The next question is, we have a secure portal that we text about appointment results. Is it safe to attach the results there as well? And then there's a question about reply consent before we start chatting with them. Most portals have a consent when the patient signs up for them, so you might want to verify that yours does have a consent up front, and once that's consented to, you don't have to get one each time. And if your patient portal is secure and allows you to attach results, you certainly can use that as a secure manner of providing patient records. Is the patient responsible to provide the patient records of services performed in the hospital, procedure, etc.? HIPAA is kind of silent on this issue, but I would just remind you of the Texas Medical Board requirement that if you have brought records from other physicians or other facilities into your record, they are now part of your record. And yes, you are required to release those. So after a patient has passed away, what is the procedure for the patient's family to request records? Texas law is pretty specific about who can request records after a patient has died. So if you would submit that question back to consulting@tmlt.org, I'll pass that on to our risk management department and they can send you some resources that they have on release of records after a patient has died. When insurance companies or third parties request medical records on behalf of insurance company to go over quality measures, how to handle this and verify that the third party company is legitimate. I think you probably need to start with looking at your contract with the insurance, and if you have questions about whether the third party is truly representing that insurance company, I would go back to the insurance company and ask for verification that the third party is a legitimate representative. Often we've seen this when a third party sends a letter and states that they're representing XYZ insurance, and the best way is to verify it before releasing lots of patient records. I think we've already covered if the patient requests by email to have his or her records emailed, is that okay? And that falls into that. Yes, you can email the records in an unsecure manner if the patient initiates a request. You've warned the patient that they may not be secure, and the patient still insists, and you document all that, then the patient certainly, then you can respond by email. Any records from a specialist's office that we request and receive we are now able to disclose those records to other providers requesting records from our office. That's not a new law. That Texas law has been in effect. Gosh, I've been at TMLT 12 years, and I believe that Texas law has been in effect since then. So this is not new. It's just one of those little parts of the Texas Medical Board rules and that sometimes kind of got buried a little bit. So yes, you can and should be releasing those. I am not seeing other questions. Someone saying they didn't see the CME launch. I'll do it a second time just to make sure it has occurred. Again, we'd appreciate your feedback. We do apologize again for the audio difficulties, and we will verify the recording has good quality, and get that out to you just as soon as possible. Thanks again for your participation today, and we hope you have a great rest of your day.